court can make a number of different orders, including a child arrangements order, and this regulates who a child is to spend time with, that being overnight or in general spending time. A specific issue order, which, to be perfectly clear, deals with a specific issue, so such as a holiday arrangement, or a prohibited steps order, and this deals with potentially curtailing a parent's right to make a particular decision about a child. If you're not on the child's birth certificate, you can still make an application to the court for a child arrangements order, a specific issue or a prohibited steps. You can also make an application to the court for a parental responsibility order, and of course a successful application would then grant you with parental responsibility, or you can make an application to the court for a declaration of parentage which recognises you as a parent. If children's services are involved, they may be looking to remove a child from one of their parents. This is something of a rather niche area for which we are able to assist, but if at any stage we feel that it requires a specialist public children's firm to assist in this regard, we're more than happy to refer a client to them. If children's services are involved, they may also be involved in relation to a special guardianship order, and this is essentially an application for a child to be placed in the care of a party that is not their parent. If children's services are involved, they may also be required to prepare a report in relation to the matter, and if this is necessary, we're more than happy to assist in that regard. You are able to ask the court, although the court will not make an order if they're satisfied that both parties have agreed and there are no proceedings in place at present. If there are proceedings in place, you can make an application to the court to vary the order with the consent of the other parent. No, there are a number of options available that you can take in rather than having to go straight to court. The first, of course, can be direct discussions with the other parent, be that through solicitors or just in person, or potentially attending mediation, which is an alternative form of dispute resolution whereby an independent mediator will seek to facilitate discussions between you both in relation to a specific matter, be that arrangements or a specific issue. The mediator won't specifically provide advice, but they will use their expert techniques at discussions and negotiations to try and facilitate constructive discussions. If the other parent has been unpleasant and you're frightened of them, we can apply to the court for special measures whereby you potentially wouldn't have to be in the same room as the other party, you can have separate waiting rooms, or potentially even have a hearing via video link so as to avoid having any interaction with the other party, as it's completely unacceptable for a person to feel this way. If necessary, we're also able to assist you in providing injunctive measures through applications to the court if absolutely necessary. It is possible at certain hearings that you may have to give evidence. If matters concerning the children are raised and the court feels it'll be in the best interests of the children to understand these allegations further, it is more than possible that you may have to provide evidence at what's called a fact-finding hearing. And also, should matters progress to what would be called a final hearing, it's more than possible that you may have to face questioning. We're able to assist you in this regard and can try and mitigate any anxieties you may have in relation to the court proceedings, especially when speaking, as we appreciate it can be a very stressful time.